you already have done this part where you have actually used the software. Now I'm just revisiting a couple of things with some examples. Now part is this, that you have already learned and familiarized yourself that this software can do few things which may be very useful in case you attempt to do a qualitative and doctrinal research. You know, what I am going to do first, I will declare that, and then I will go step by step. And you will see that it would result into some specific learning which we intend to do with this session. My objective of this session is that let us revisit few things with some live example. So I'll pose certain examples of typical legal research. Social science also it will cover, but predominantly the legal research. And suppose you are having that research problem, and how you will make use of manual analysis of the data, qualitative data, and manual analysis of the doctrine. So this I will do. So when you will go through those steps, you will recall that software can be useful at certain places. This is what I am going to do. And I will make it very simple for you so that you will read it. Because I am still thinking that we need to first differentiate between these two terminologies which are being used. Doctrinal, as I said in the first day, is a typical term which we use in case of legal research, because we are analyzing the doctrine. And when we say doctrinal research, essentially we are talking about a research which is analyzing certain legal doctrine, and I will discuss what is that very briefly. I am not going to give you all the actions. Second, I am also using the qualitative. Can anybody quickly tell me what is the difference between these two terminologies? Doctrinal and qualitative. I am asking this question in the end of the workshop. The rest is self-explanatory. So can you tell me that what is the difference? If at all any difference is there. Because we need to achieve this clarity. Otherwise it will continue to be there. Because I am more worried about the vague concepts that we carry out all through. If you are moving with vague concepts, it's like human bomb. You can explode anywhere. Let us be a little careful about our terminology and uses. So please tell me, what is doctrinal and what is qualitative? So, no response? Should I draw what I intend to draw?
Doctrinal is a type of research in legal research.
Yeah.
And quantitative is a method in getting data.
Yes, that is okay, but this is not enough. Every line is important, and let us be very careful about what we say. That's why in research I always say, why research methodology is a core portion? Because it gives a temperament of thinking. You become a person with some articulated understanding in order to reflect on an issue. Whenever you will speak like a mathematician. I want that kind of temperament to be achieved. Now look, let us see. So if I take the Martha, the dean of Harvard School, she has come out with, though there are a lot of definitions, let us see what she says. She said doctrinal research is about organize and reorganize case law into coherent elements and categories and concepts. So you are dealing with a doctrine, legal doctrine. So suppose if I am dealing with the doctrine of criminal responsibility in criminal law, how it has evolved, or if I am dealing with the doctrine of general exception in the principles of criminal law. Now the origin of the doctrine of general principle, general exception in criminal law has originated, and it has passed through different phases. In contemporarily speaking, it has got influenced by a number of developments which have been happening in the society, in the law, So like for instance, the developments in psychiatry in the 19th, the beginning of 20th century, it has impacted because then the knowledge was that human being is influenced by so many things, therefore he is unable to exercise the free will. This development happened because you are not an independent actor. So if you are not an independent actor, means you cannot exercise your free will. So you cannot form the mens rea. Therefore, that would fall in the category of general exception. I am not discussing this issue, but I am discussing the analysis of the development of a doctrine over a period of time, getting it influenced by contemporary developments in parallel spheres of knowledge and all those things, and how it has been. This is the doctrine. So Martha said, organize and reorganize. Now case law. Now case law becomes a very important source which shapes the knowledge pertaining to that particular issue. Like privacy issue. Like for instance the 377 issue. All these things were there earlier. The IPC is very old, 150 years old now. But why it has not happened then earlier? Because the knowledge which we are deriving, LGBT movement is a very new movement. So LGBT related understanding is of a very recent origin. Therefore, law will change today. So something happened today which has impacted the course of development in the field of law, and therefore the law is being changed. And therefore we have also significantly altered so many notions which have tremendous impact. I am giving. So certain questions, so first is organize and reorganize case law into coherent elements, categories and concepts. So if I take up some case laws on the matter of the rights of LGBTs, and I find that there is a chronological development. So initially the cases used to be there, but they have been overruled because nobody would recognize at that point of time. Like for instance, euthanasia, or for that matter, suicide. So initially the case was ruled out, no, a person cannot be allowed to die because this is illegal. But now it has changed. So what has happened with change? So if you read case law on a cohort, in a continuum, then your understanding will be very different. So meaning that I am deriving, in order to understand the doctrinal research, that if we put together all the developments in the field of knowledge pertaining to that doctrine, we reach to a cumulative understanding which is bound to give us some ideas about the way we perceive a particular problem. And this has happened to all the concepts in the field of law. You take it anybody, either it is in criminal law, constitutional law, environmental law, all these things have, covered a journey. Second, she said acknowledge distinction between settled and emerging law. Settled and emerging law. What is the settled and emerging law? So like for instance, privacy law is emerging law. Now Aadhaar is being discussed today. Today is a D-Day for Aadhaar. Now emerging law is because this tussle between the individual right and the state security. It has been a long drawn battle. Whether the state's rights are supreme as far as the state status quo is concerned, or how the individual is placed vis-a-vis the state, who should be given supremacy. Because thinkers in criminal law say that criminal law should be the last resort. They say it should not be invoked unless there is a compelling reason to invoke the law. So this is a thin line difference. So what is the emerging law? So like for instance, many areas like cyber law. Cyber law was an emerging law, now it is settling. So what I am saying, doctrinal research means to understand the settled law and emerging law and that particular. Because today, standing today, you may not be in a position to acknowledge and understand the consequences that might be thrown up by a particular process, like for instance artificial intelligence. Artificial intelligence is an arriving thing. It is arriving very fast, and there is already a debate going on that what will happen to the situation where a robot comes in and claims the rights like a citizen, whether they constitute, because artificial intelligence means the machine machine run robot would be in a position to exercise the brain also. They can participate in conference, they can be doing so many things. So what would be the legal status of the robot? Now law is not clear. Though European Union has already started debating it, Australia has already started debating it, and the professor who visited us in Germany last time, he has already done a book. He is doing a research on artificial intelligence in criminal law. Now arriving law, settling law. Doctrinal research, so suppose you are doing a research on criminal responsibility, you have to take care of the law which is arriving in that particular field, medical law. Now medical law is settling, consumer law, responsibilities, individual, state, so many things are. So doctrinal research means how a concept has traveled the doctrinal journey up to this point, and what are the futuristic implications of that doctrine when it will be applied to an act or a situation. Are you getting my point? So a doctrinal researcher is bound to take care of these aspects. Third, identify the difference between majority and preferred and better practices, ideally with some explanation for the criteria to use. So what is the preferred and better practice? So in any field, these things can. She also said that there is a way to recasting the project where we can gather more than one line of cases across doctrinal fields or categories and show why they belong together or expose unjustified discrepancy and offer a framework. Idea is that suppose you have a situation where you can choose a particular line of cases, like death penalty jurisprudence has evolved, like following a typical line of cases. So suppose if I say that that why court tend to commute the sentence in case of death penalty into life imprisonment. So the answer is that we follow the Bajpai doctrine where mitigating and aggravating factors are then examined. Now doctrinal research can look at both the line of cases where mitigating factors are appreciated, where aggravating factors are appreciated. And if you study 100 judgment or 200 judgment, you will certainly come to an understanding where you will be able to draw a pattern when the courts are most likely to commute. A single case cannot answer this, but a line of cases can answer you, and you can be predictive in doing this research in terms of saying that courts are more likely to commute when, say for instance, professional background or nature of offense is such. Now if you put, but you have to take the cases in a pattern and in life. Doctrinal analysis is this kind of. So inference drawing is a very important technique. And I am telling you, so suppose as a researcher, you are doing a research on any concept. You need to choose cases very carefully, and you need to draw and identify the pattern. So software is doing, by coding, by memoing, you can collect the cases which are kind of, I'll discuss the study which we are doing on gender insensitive remarks. So suppose I am into studying how often, please remember, every doctrinal study that you intend to plan must begin with a carefully articulated question. If you do not have a question, you cannot do it. Like for instance, very interesting, today's Indian Express. So this is very interesting because we generally do not read like a researcher. We read like a layman. You know what is read like a researcher and read like a layman? This is interesting. How do we read? So if you read like a researcher, then this is very important. Today itself, I am not using last. So this is the Aadhaar case. So putting all petitions together, court is looking into, and they have formulated, see, court is also doing a doctoral research. They have formulated 3 questions. Why court is formulating these questions? Because they cannot look into all the petitions individually. There are several petitions. Every petition cannot. So see, now this is the research. First question is, does the government have the right to demand that every person authenticate his or her identity through biometric or demographic information with just one proof, a unique identification number, to make sure that government benefits reach their intended targets? Or do Indian citizens have the right to identify themselves using instead any of several other documents issued to them by the government? I think it's a very carefully, clearly crafted question. Now, answer of this question will lead to doctrinal research. Because then you will analyze the law. What is the law? What is the constitutional provisions dealing with these two? So, 2 situations the court is formulating. Whether insistence on using unique identification number or allowing the citizen to use any number. Whether this choice is available with the citizens or not. This is the question. Now, this question can take you to the rights of the individual vis-a-vis the state. Now, if you get into this question, you will have to collect the material to weigh both the situation. And then probably you reach to analysis. Now, second question. Is the Aadhaar project an attack on person's privacy? Now, a fundamental right. Now, it is a fundamental right after the Supreme Court ruling that arose out of the Aadhaar case itself. So, whether Aadhaar is a contradiction or a threat to privacy? No. So, if suppose your doctrinal project is this, only if you take a second question, it becomes a doctrinal. Because what you will do? You will try to understand what is the limits of a state interference as far as the individual liberty is concerned. You will go to Miller. Right from there. No, and then you will analyze what other countries and other jurisdictions have followed. Now you will bring the material. So because you have a hypothesis before you, a research question before you, so your material collection efforts are more and more directed rather than haywire. Third, is the Aadhaar Act valid given that the way it was passed has been changed? So whether this is valid or not. Now, I am trying to tell you that every case is decided based on certain doctrinal research. Even LGBT was decided with the question. So invariably the question in such cases is to understand what are the limits of state interference in the domain of individual liberty. Now this question can be answered in several ways. Now you will not depend on your ideology. You may be a very passionate champion of individual liberty, but that is not enough. You will have to bring the evidences from various jurisdictions, different material, the historical jurisprudence which has been created on. So this is the doctrinal research into the making. Are you making sense of what I am trying to say? So let us see what Martha said. She said, the next is policy analysis. Now, because we are getting into, because Aadhaar will become a policy once this case. So what does it mean? So we have to present a problem. There has to be a problem if you are analyzing the policy. Now there is a problem. I always say research is a journey from question to answer. So if there is no problem, there cannot be a research. So problem is the limits of state interference in the domain of individual liberty. Basically, Aadhaar is not a question. People think Aadhaar is a problem. Aadhaar is not a problem. What is the problem? The surveillance, the privacy issue, the liberty issue. These are the Aadhaar is simply a tool. So today it is Aadhaar, tomorrow it can be anything. So if you know that in England the Big Brother watching movement started against the state surveillance through CCTV camera, because England is the most surveillanced society as far as the CCTV is concerned and the reach of CCTV. Big debate happened. So they said, we are not per se against the CCTV, but what are the limits? Let us understand whether you can put CCTV camera in this room or what are the things. So a lot of policy is evolved. So Martha says that policy provides the alternatives. So doctoral research result into the better suited alternatives which can honor or which can cause a kind of balancing exercise as far as the tension between these two domains are concerned. So they propose an evaluative scheme, a method, a preferred solution. So doctoral research is cost. So when in this Magna Carta came and criminal responsibility was decided, so Durham and this case happened. So then Robert Peel was the Prime Minister. He was targeted by this McNaughton rules. McNaughton mistook somebody, the secretary of Robert Peel, as Robert Peel, and he shot him, he fired at him, and he died. And till then there was no general exception in the rule book of law. So the question arose that whether McNaughton was correct, whether he was suffering from any error in his judgment, and then entire case law came, and criminal responsibility was diminished. And criminal responsibility was, so criminal responsibility is not an absolute thing. This principle was laid down in the McNaughton rule. Durham was a thief in US. He used to do the stealing not because of the need, but because of a psychological psychiatric disorder. So result came that he is suffering from acute psychiatric disorders. The court realized, can this person be granted the relaxation in the criminal responsibility? Because again the law was not clear, law was not giving any. So a new law was contemplated and there was a debate. So how the doctrine of criminal responsibility from absolute to relative came into the existence. This is the doctrine. So today when you, privacy law will be maturing very soon. So when you study the privacy law, you have to look why privacy. Earlier there used to be a complete secrecy of document. The RTI was quite in conflict with the Office Secret Act, Official Secret Act. So the Official Secret Act used to allow the government to hide virtually everything. Now RTI has completely conflicted it. RTI is just kind of paradox. So journey from that act to RTI is a game changer. But how it happened, what are the factors? This is the doctrinal research. So evolving of a law, evolution of a policy, and the maturing of the concept allows you to undertake the doctrinal analysis of the relevant development in the field. Now to test a proposition, another thing is, we want to test a proposition. So if I take a widely assumed or commonly known proposition, familiar to lawyer or legal theorist, and try to undertake an empirical investigation about the way it is working or the way it is changing. As I said, the doctrine of mitigation came in the domain of death penalty jurisprudence. So mitigation was something which is not the part of the formal black letter law. It has evolved through the adjudication and the trial of the cases. So doctrine of mitigation was evolved that yes, this is important. Like for instance, the criminal responsibility of juveniles. Now juveniles used to be punished like adult. This was the law. But why the juvenile they have been treated as separate class because we are now aware, the science has evolved that a person up to this stage or age is unable to form the menstruation. Now this is again in discussion after Justice Verma and after Nirbhaya case, we are revisiting the law and we have changed the law. So how the knowledge and knowledge spheres change and they impact the law. Now we said no, even in certain cases, a person below 18 years of age can be tried like adult. ये law हो गया कि नहीं हो गया? Isn't it? Now why? Why? Can you answer me why this proposition was added? So suppose the doctoral research is to test the validity of the proposition of reducing the age of criminal responsibility in selected case in case of Juvenile Justice Act. What is the reason? Right? Otherwise, it is no offense if it is committed by a person below 18 years of age.
So sometimes it's not about the age factor, it's the psychological factor and the environment.
So what is the theory? There must be some broader principle behind this entire process. What is that?
Do persons under the age of 18 have the mental capacity to commit crimes?
This is the question. So this is the question, do the persons of this and this age in certain situation can form the manslaughter, sexual act especially. Now, this is the doctrinal research. If you get into the why of the law, problem is we don't get into why of the law. We look at the black letter law and do not question. So suppose why general exception? Means you are being driven to doctrinal research. Isn't it? So what I am saying is testing the proposition. So if you have a proposition before you which allows you to look into why of the law, you are into the domain of doctrinal research. Are you getting me? What I am trying to say? Let me tell you. The criminalization. Now I am talking these issues which are currently in the newspaper. A big debate is going on whether the triple talaq has been rightly criminalized or not. If you discuss, you have to answer whether it's right or wrong. But do you think it is a doctrinal answer? What is the doctrinal answer?
Why it is
What acts are criminal?
So, what are the question would be, in general, what are the principles of criminalization or decriminalization? And how do these principles apply in the criminalization of triple talaq? Whether the test of criminalization principle hold true in case of triple talaq criminalization. This is the doctrine. And the moment you undertake this question, you are into the process of understanding criminalization historically. So when an act becomes ripe for criminalization, when an act becomes fit for criminalization, I have scanned hundreds of articles which have published in all these months. I have found none, virtually none, talking about the principles. And the principles are very clearly laid down. If you analyze the jurisprudence, Miller, right from Miller says the act must be blameworthy. The act, no, yesterday is of course a lawyer, Diwan, lady, lawyer, she wrote the article in Hindu. She has raised this question because doctrinal question, can civil acts like triple talaq be chosen to be punished like a criminal act? Doctrinal question. You cannot answer in yes or no, बहुत अच्छा, मुझे अच्छा लग रहा है. This is a foolish thing. It is a vulgarity. आप कुछ नहीं कर रहे, सोच रहे ऐसा ऐसा. I am talking about facts gathering. What are the facts? You know, wool gathering and facts gathering. Wool gathering is a dreamy act. Facts gathering is actual act. So what? So do these questions take you to the analysis of the history, philosophy, the making of principles? Because all laws are based on certain informed principles. Whether these principles hold true or not, that is the. So if you have to do the doctoral research in any domain, probably you have to trace the jurisprudential and doctrinal origin of all these things. Even the civil wrong argument. Civil wrong argument is very important, which Diwan, she is writing, and she says we have to decide when civil acts become punishable like criminal. So, because talaq and related matters, matrimonial matters, are in the civil law. And she says, very rightly she says that criminal law punishes something which is a public wrong or a public harm, publicly harmful act. So what kind of public wrong this triple talaq is causing? So does this qualify to be punished like a criminal act? तो अब उसमें किसी के पास जवाब नहीं है. करें हाँ बात तो ठीक है, बट इससे लोग ऐसे जवाब नहीं होता इन चीजों. आप उसको you have to qualify this thing. लॉ में ऐसे नहीं चलेगा ना. You have to be very clear, because when act becomes fit for criminalization and to be punished by the force of criminal law, because criminal law doesn't punish any act because an individual was wrong. They look at the social consequences of or implications of that act at large. So a person is not only being punished for committing the theft, he is also being punished for the impact that act is likely to cause on the community at large. So community consequences are the central of the punishment being awarded. So where does this triple talaq qualify, the public harm? आप अपनी बीवी को 3 ने 6 बार तलाक कह रहे हैं. How the society is, that is the whole argument. आप privacy में यही तो कह रहे हैं. How are you concerned if it is a matrimonial matter? या तो आप उसको you justify the public aspect of it, public morality. जैसे जो sexual obscene acts, उसमें हम कहते हैं public morality is at this stage. Constitutional, yes.
Sir, I just wanted to raise an argument. When I talk about civil acts and criminal acts, when we do our basic class on torts, we say that there are some acts which are civil, some are criminal, and some are tortious liability. We do give a point that there may be acts which are having both civil and criminal consequences. For instance, of riding of a motorcycle.
Defamation, like.
Defamation. But when I go to this defamation judgment in that civil liberties, the common cause case, 2016, the court has elucidated, though we may not agree with it, that it is the will of the society, that is the wording of the court, that it is the will of the society which decides whether criminalization should happen or should not happen. And what is will of society again would lead us to the debate that we are currently having, that will of society is whether public at large would be harmed or not, or what do they construe. And they said that the will of society is there in the legislature, so it is for the legislature to think whether a law should be criminalized or not. That's how they have related it to.
Yes.
So they've left it to the wisdom of the legislature as the determinative factor. If it considers yes, it should be criminalized, then it should be, otherwise it should not be. Similarly, the judgment which came yesterday, that was on this criminalization of politics. Again, the same argument which was advanced in the previous case of criminalization in that common cause case has been used here, that if we want to think about criminalization, who is in the best interest of society? So the collective will of society, that is the word. That's best left for the legislature to determine and not for individuals. Because your standard of thinking may be different and mine will be different, but it is the collective will of the society who is doing it. Maybe they are giving it importance to the legislature and they are trying to have that power of separation inbuilt, and that's why that's the reason. the point I want to draw here is one, that there will be different standards of thinking of criminalization. Therefore, the ones that we have elected should better think. Second point is that it is not just triple talaq, that is one offence related to marriage that we have carved out. We already have a chapter in IPC which talks about offences against marriage. Yes, chapter 22 if I'm not wrong, I'm not sure about it. So it's not for the first time that we have criminalized. They're already there. So why is bigamy an offence? Why is adultery an offence?
Adultery one.
Yes.
So that is what I am saying. These are some questions where which are kind of borderline issue. The question here is not whether that is correct or this is correct. What the question is how you are deciding it. What is the standard of decision? How you decide on these things. That is criminalization of politics. They have refused to not to interfere, not because that they have a problem with that, they per se reject this. They said the act of creating the law, this rest of the legislation, and let the legislation, how often the court will do this work. So they said that you bring an ordinance, we bring an act, and then we will criminalize it, no problem in it. So, but there are certain fundamental issues. What I am saying is somehow on the issue of adultery, euthanasia, triple talaq, and the quantum of punishment, so many things, probably we are forgetting the fundamental principles which have been, I don't have time because that is not the class for that, which are already very well settled and clear, and which are being invoked in all other societies. We are not somehow using that. That is the whole issue. If those have been satisfied correctly, probably the touchstone becomes far more acceptable. Now let us go to the remaining part of this. Then there are some other issues where we are doing the doctrinal analysis. But I'll now come to the qualitative. This is I'm not in a criminal law class, I am in a research methodology class. Now I'll come back to what is the qualitative that we are talking. Please remember, I am very clearly differentiating. Doctrinal is completely related to the doctrine in law and the analysis of the material that you identify for that purpose. So that is a different class. The qualitative expression is mostly live with the social science research. However, a lot of research in socio-legal category, especially in law, we use where we also employ certain methodologies which allow us to collect a lot of qualitative material. Now, what is the qualitative material? Qualitative material is the one which we gather either through interviews, observations, focus group discussion, text, films, interviews, ethnography, observations, so many ways. But that data is conversational. That data, like I am in conversation with you to understand. I can generate a lot of qualitative information from you, the way you work, the way you decide, the way you feel. That information is not really in quantitative terms, but there is a wealth of qualitative information which is resulting into my interaction with the either living objects or non-living objects. So nature of information is qualitative. When nature of information is qualitative, we are saying we employ qualitative model. It is qualitative because my efforts into research are resulting into the generation of qualitative information. What is qualitative information? Can anybody give me an example? No? That's why you cannot perceive unless you see it. So qualitative information, if I say this picture is very beautiful, this is the qualitative information. If I say the frame is 2 feet or 2 by 3, this is the quantitative information. So all the time information is not measurable. So whenever it is not measurable, it is quality. Like you read a judgment, you don't get numbers, you get merely information. So suppose you want to say, court has pulled up the government. Pulled up ये तो नहीं रहता कि 6 feet pulled up, 60 kilo pulled up. No? Pulled up is pulled up.
Pulled up heavily.
Pulled up heavily, coming down heavily. To put it, अब और ज़्यादा adjective उसमें आप जोड़ते जाए, it will be changed. I am saying law as a subject is of such nature where you end up with collecting lot of qualitative information. So suppose I am doing an intense interview with say any veteran judge like anybody, if I am in Justice Krishna here, this thing, I want to know the jurist. Now there are books on those these experts, Fadi Rehman and Nana Palki. There are books. Now those books are the experience sharing. Now that experience sharing gives you a wealth of information which is qualitative in nature. They cannot tell you in numbers that we have been very effective and we have done this, that. But you can certainly draw inference that what is their specialization, how they have done it, is there a particular way that they have been doing, like you have derived the entire PIL idea from Justice Bhagwati and Justice Krishna ideas. They have given birth of the entire jurisprudence. No? Qualitative. So qualitative information is, suppose you are doing, you want to understand how the tribal people make decisions with respect to the disputes, civil and criminal disputes in a tribal society. And you as a law researcher want to understand how the tribal people, tribal panchayat in the remote areas of Madhya Pradesh, Jharkhand, Chhattisgarh, they sit down and decide. They have a tribal dispute mechanism. So, what is the method that would be most suitable?
Go and explain.
Hey, what is that? अभी मैंने बोला था observation. Observation is not simply seeing. What is the difference between seeing and observing?
It's a purpose.
Observations results into gaining the insights. इसीलिए आप हमेशा नहीं कहते कि I am observing. When you say I am observing, you want to connote a different expression. So in research, observation. Now observation is extreme. Suppose you want to understand how do the court decide. So I send my student to observe that cross-examination. Qualitative research. It's not a doctrinal research. No, I am telling you, this is the mistake that you do. Why it is not doctrinal? Because we are not analyzing any doctrine. We are collecting qualitative information through our object. So best example is, you want to understand how cross-examination takes place in the court, and you want to sit 30 days. You want to observe 30 trials to collect the data. How you will collect the data? ऐसे वहाँ बैठ जाएंगे जैसे सिनेमा में बैठ क्या करेंगे? Observation is informed by methodology. हमें एक शेड्यूल बनाना पड़ेगी, that is called observation schedule. So probably we will try to understand what is to be observed. So suppose if I write the duration of pleadings put up by the defense lawyer and anything observable, the force, the knowledge, the skills, so many things we can observe, mannerism. Mannerism is very important in the court. If you want to, and still you are collecting the data in a kind of pre-decided format, but still you find a lot of things which are not the part of that tool, so you are making notes also. Yesterday he was saying how the field notes are prepared. He couldn't give you this example, but I am giving you. So if you want to make certain notes about the trial room ambience, जैसे आप आई एम श्योर आपने ट्रायल कोर्ट्स देखे होंगे जो डिस्ट्रिक्ट मजिस्ट्रेट क्लास 1, मजिस्ट्रेट क्लास 2, सेशन कोर्ट, इन सब का बिल्कुल अलग होता है एक्सपीरियंस. हाई कोर्ट का बहुत अलग है, सुप्रीम कोर्ट का अलग है. If you want to do a comparative study of the courtroom ambience, of a district court and a high court. Very good study. It will give you a lot of insights. बैठने जगह नहीं है लोगों को. जॉली एलन भी देखा होगा आपने, ज़्यादा नहीं देखा होगा. क्या देखा उसने? पंखा वो कहता है साहब यहाँ तो फैन नहीं होता, एसी चलाओ. क्या जवाब देता है जज? डायलॉग याद रखो, सिनेमा हमेशा देखा करो, याद रखो. और काम की चीज बाकी तो समय में. So what I am saying, you become suddenly a very keen observer of collecting lot of data. Now, the skill doesn't lie merely to observe and record the data at this stage. How that data can be used finally for, so that is one situation where you are observing. Suppose you are not doing this. You are only doing the work that we had done. We are mapping the gender insensitive remarks by the court in the court judgment. So I am now interacting with text. What is the difference between interacting with the text and interacting with living person, like courtroom situation? जवाब दो आप. कई बार ऐसा लगता है आप जवाब दे सकते हैं, लेकिन कुछ बंधन है जिंदगी में आपके, अलाउ नहीं कर रहे हैं.
Interacting with the text will be doctrinal based and with the.
No, not necessarily. देखो मैं यही कहूँ. See, you cannot verify. You cannot ask. Living, you can ask. Suppose I have an interview with you. I can always ask, what do you mean by this? But with book, you cannot ask.
So when you interact with text, it's fixed.
It's
You cannot,
fixed.
you know,
Yes, exactly. So now I am coming to that method. So qualitative research is a bunch of several things. It is a method of data collection. It is a method of analysis. So please remember this. It is a method of data collection and it is a method of analysis. So what is the difference between collection and analysis? मैं मान के चल रहा हूँ आपको ये पता है, लेकिन कई बार मैं अपने आप को चेक कर लेता हूँ. ये this conversation is clear to you? देखिए, अगर आपको कोई चीज समझ में नहीं आ रही बाई द वे, तो आप समझ लें कोई बहुत इंपॉर्टेंट चीज कही है. उसको आप पूछिए, प्लीज आस्क. So what is the difference between data collection and analysis?
collection is when you don't have something and you want to have some basis, and analysis when you apply your mind on whatever you have. So
No. Collection means like in empirical research. Suppose you go with an interview schedule, you collect the information and you come back. In qualitative analysis, generally the collection of information, especially if you are dealing with a doctrinal qualitative. Now doctrinal qualitative means they cannot be separated all the time. Sometimes doctrinal qualitative is going together. Like quantitative qualitative may go together. Please do not mistake that they cannot go together. So if you are doing a doctrinal qualitative together with the text, so suppose you are mapping a doctrine in the text. So you are collecting and analyzing it. These two things go together. I am giving you a conceptual clarity. So next time when you talk to somebody, and if you are talking about doctrinal qualitative, it means you are talking that somebody is analyzing, somebody is collecting information at the same time, he is also developing the theory and thinking on that topic. So you are discussing the entire trajectory of development of that thesis, how that thesis came into being. So you are bringing qualitative. Qualitative is the nature of information. So all the information which is textual in nature is qualitative. You know? So I'll give you a model which you have already seen, and probably that will give you more idea. And then probably we can show you the research also which we had done, which can bring you more insights. Basically, the qualitative data analysis goes like this. I told you that there has to be a a research problem in your mind first. Why there is a problem? Because generally the research problem is not clear. So yes. So research problem, research purpose, research question, and appropriate techniques. This is the model which is followed. So you have a research problem. So suppose I want to understand that in how the court has exercised or how the court has dealt with the mitigating factors in commuting the death penalty into life imprisonment. If this is my question. So what are the factors which the court has considered to be important? Suppose I want to understand in last 20 years, what are the factors which the court considered to be mitigating when the court decided to commute the death penalty? Now let us see. Okay, this is a problem. What is it? So I think few things. You look at I think you have to check this, it's visible to you. So data collection is something which is very, very important. Data collection, data display, data reduction. What is these things? Data collection means I have already informed you. Second is the data reduction. So a lot of information is there. By putting coding and all those things, you are reducing the data. And then third thing is data display. Finally, you will display a set of data which you have collected. And finally, you will draw your conclusion. This is the model in the research. Let us see how it goes when you analyze the research. Now this, if you remember this entire plot, then things will be very easy for you. You know, what does it convey? First of all, data collection, then data display, then reflection on data. So suppose I want to, if I am collecting the data from courtroom situation or from text, I am reflecting also. What is the reflection is a very important word. Means you are not merely a passive collector of the data. Like in quantitative research, you don't reflect because you simply collect and forget because you did. But in qualitative research, you try to interpret the data. Why the court has remarked like that? So suppose court is seeing, made some remark that no, like suppose in recent case, Justice Chanchud says that the police should not have done the press conference on the matter which is already sub judice. No, this is not merely a kind of remark. What is the rational reflection which can be drawn from it? Fair investigation. He is talking about the fairness of investigation. So these concepts are very permanent. Court may be speaking in a different language, left and right, on these concepts. What researcher requires. So suppose court issues certain remarks and directives to the state government or to the police agency, you know, a kind of a very tough language. What they are insisting upon? They are insisting upon the fairness of investigation. Or when somebody is saying against the court There again court is coming out heavily. They are talking about the independence of judiciary or any other thing relating to that, ethics and so on. Data coding. Now data coding you have done. So you have to code the data, even manually you can code a lot of data if you are reading a text. And then data distillation or data reduction. You are removing irrelevant data and you are plotting and collecting only the data which is useful. If you are doing your PhD thesis or anything, you can use this diagram to tell about your methodology. So next time when you propose a research to anybody, you can use this diagram that this is how we will do the doctrinal analysis or a qualitative analysis. Then generation of themes and then the story. So themes are created and then the story is conveyed. The story is conveyed, not you are conveying. The story will be formulated based on the themes finalized and collected. So suppose I finalize themes that out of 10 occasions, 7 occasions the court advertently or inadvertently used some gender insensitive remarks. What is the inference that you can draw out of this? What is the inference? इन्फ्रेंस ड्रॉ करना एक साइंस का काम होता है. जैसे आप दरवाजे से निकले 2-3 बार और गिरते पड़े 4-5 बार गिर पड़े तो आप क्या कंक्लूजन निकालेंगे? कुछ इंजीनियरिंग डिफेक्ट है. ये ड्रॉप ये तो नहीं कहते कि ये तो ठीक हुआ भाई गिरते रहे. Nobody enjoy these things. तो कुछ तो कंक्लूजन निकालेंगे. When a thing tends to recur, it must lead to the drawing of certain inference. This is what I am trying to say. And drawing inference is all about researchers. Because most of the people stop there. आप collect तो बहुत कुछ कर लेंगे. ये भर गए हैं कंप्यूटर. 2 टीबी इंफॉर्मेशन भरी हुई है. इस पे कुछ नहीं हो. ये बोझ है. You are carrying this load for no reason. वो डाउनलोड कर दे रहा हूँ. इसको और कुछ नहीं करना.
अपलोड नहीं हो पा रहा.
अपलोड नहीं हो रहा. अभी तो डाउनलोड करो फिर देखेंगे इसका क्या करना. फिर भूल जाते. तो बाद में 4 साल बाद देखते कि फाइल हमने डाउनलोड की. आप हमेशा डाउनलोड इस सोच के करते कि इसको पढ़ें. लेकिन डाउनलोड करते ही तय हो जाता कि अभी पढ़ा नहीं जाएगा. किताब जब 2 दिन के लिए मिलती थी ना आपको बारो, उस समय सब पढ़ते. अब किताबें बहुत हो गई हैं, लोग खुश हैं.
पढ़ते नहीं.
तो पढ़ना खत्म हो गया. चैलेंज जब तक जिंदगी में नहीं आएगा कोई काम नहीं. लिविंग ऑन द एज की जो बात आती है कि जब थोड़ा कष्ट रहे आपके जीवन में तो आप ज्यादा मोटिवेटेड हैं. वो हो नहीं रहा है. सब सुकून भी है लाइफ में. अच्छा है. It's no problem. But what I am trying to convey is that inference drawing has to take place based on whatever you are doing. So computer will not do, even if you are using Atlas TI for all these reasons and you have collected code category. But what is the inference that you will draw? So suppose I draw a lot of, I do a lot of cases, I put so many cases together, and whether I am seeing that these things are making something or not simply it is a kind of. Abhi I wrote an article in Indian Express 2 days ago. So I was reading, this is the doctoral research. So I was curious to know whether the happiness has something to do with rule of law. So I studied rule of law also. Then I find the happy nations are those who are also good at rule of law. So rule of law is better, happiness level is better. No, this is the inference. You can draw these inference. Happy people are more law abiding. No, you can challenge this proposition. I don't know. These things then somebody can challenge this proposition. More data can be collected. But ultimately you have to draw something. This is thesis. When you write thesis, I always try to understand from researchers that what is it that you can claim it to be original or it belongs to you. What are your inference which you have drawn from your own analysis, based on something. हवा में inference नहीं निकलता. Inference is drawn based on the material that you accept. अब होता है कि मटेरियल जो आप कलेक्ट कर रहे हैं उसका कंक्लूजन जो आप निकाल रहे हैं उससे कोई लेना देना नहीं है।
कंक्लूजन पहले बना।
कंक्लूजन कई बार आप, मैंने एक और बड़ा अजीब ट्रेंड देखा, कंक्लूजन आप जो लिखते हैं और जो मटेरियल आप कलेक्ट करते हैं उनमें कोई संबंध नहीं। उनसे पूछ के कंक्लूजन तो मैंने वहां पढ़ा था, किसी दूसरे का कंक्लूजन आप अपनी थीसिस में ला, मतलब ये कितना बड़ा गुनाह है। मतलब ये है कि कंक्लूजन बिलोंग्स टू समबडी एल्सेस वर्क। आपको लगा तो आप कई बार कंक्लूजन से का कोई लेने देना नहीं देता, लेकिन कंक्लूजन तो बहुत अच्छे जैसे आप दूसरी चीज कलेक्ट करते हैं वैसे कंक्लूजन भी कलेक्ट करना। कंक्लूजन तो अपने रखो कम से कम। दिस इज द क्राइसिस ऑफ लीगल रिसर्च इज दिस। और उससे ज्यादा है कि nobody realizes that it is happening। एक बड़ी खूबसूरत सी नींद में हम लोग सब चल रहा, खुदा चला रहा सारी रिसर्च। So let us see more. So this iterative logic, what is iterative and simulation? These two words come, and doctrinal research goes lot of iterative, means to and fro, and lot of simulation. Simulation means if you have noticed something to be happening in one jurisdiction, how that thing is happening in our jurisdiction. Like for instance, restorative justice was attempted in the US, where it was tried that the people should be brought into conciliation, mediation in criminal matters, and also some petty offences can be done through restorative justice model. This is the American model. Now in India, somebody has to simulate to what extent this model can go. So again, these things will give a lot of insights. So describing, connecting, classifying. Basically these three things happen in qualitative doctrinal research. But these words have some meaning. Please remember, what is describing, what is connecting. Connecting means, as I have connected law and happiness, this is the connection. Can you connect similar things? Like for instance, if I say GDP is going high, and economic offences, what is the impact of economic offences? If I say delicensing has resulted into multinational or transnational organized crime, kind of thing. Connect. Connections we have to find. Why connections? Again, what is the logic? Logic is nature is orderly distributed. Everything in the nature follows a sequence, whether it is a crime or it is a peace. Things follow a sequence, and searching the sequence is the function of research. So basically, can I have this call, please? Hello. Yes, please. Yeah. Sorry, this is the part of my other duties. Now, let us see, this model is, now these diagrams provide you tools. Now I am telling you, the problem in qualitative doctrinal research, unlike quantitative empirical research, is that you do not have anything tangible to see. If you keep such tools before you, then probably you will understand that how the thinking, because thinking follows a logical pattern, then you can guide your thinking in that direction. Like this is called the iterative spiral. So when I say, suppose you are looking at judgments and you are mapping the judge's behavior or conduct or analysis on certain points, then you have to go through. So in judgment, these things will not follow a sequential pattern. So sometimes it is on page 1, sometimes it is on page 10, sometimes, and every time there would be a context. Without context, no expression happens. So you have to understand that how this plotting is possible. Now that is the Atlas AI can do. So you have to find out what are the variables. So suppose I am like the research that I am going to show you. When we were mapping the gender insensitive remarks. Now, no judgment right that I am making a gender insensitive remarks here, you please collect the data. No? How will it happen? You have to decode certain expression and need to code them as gender insensitive. The coding belongs to you. So sometimes there are inappropriate observations. So I was tempted to write a full paper when in a university in Sonipat, the rape case happened and Punjab Haryana High Court judge made some remarks. You might have read a newspaper which kind of created a voice that victims should not be blamed. Doesn't matter what is happening. You cannot blame either the accused or the victim like that. So victim's behavior is sometimes questioned by the judge that what that girl at 2 o'clock was doing, this is inappropriate. No, this is about being too judgmental. Though judge's job is to judge, but not to judge the morals or the other things, kind of thing. So wherever you find something inappropriate expression, you can code that expression. In order to do that, you have to sort of follow this particular process. Is it clear what I am trying to convey? These things you can do with software also. But let us see that what I am trying to say. The data analysis is an eclectic process. Now, what is eclectic process? It's a dynamic process. This process is not only you are collecting the data, you are also giving a kind of rise to certain new concepts. So same judgments can be read for various ways. And every reader, depending on your position, you can draw. So like if a feminist researcher is reading judgment, her engagement, his or her engagement would result into the drawing of information which an ordinary reader may not be in a position to draw. Eclectic data collection. So that's why I am saying when a judgment is read, it can be read in various ways. So suppose I want to, I always, because I have read a lot of judgments by Justice Krishna Iyer, and I can say with a lot of conviction that suppose, so you can read, suppose I have to read social justice doctrine in Justice Krishna Iyer's judgment. Justice Krishna Iyer is not writing any para on social justice. But he is doing a lot of social justice connotations through his expression again and again. And so suppose if I decide to do a research mapping of social justice doctrine in Justice Krishna Iyer's, is it possible? Very much possible. And I am sure many persons might have done it. But nobody might have done by using the tools which I am. The only difference that I am making and your presence here today will have the understanding or the benefit of understanding that you are already doing these things. What I am adding, that I am making you aware of certain tools which you can use consciously in your analysis. That is the job that is being done here, nothing more than that. The fundamental principles will not change. They will continue to be like that. So mapping of social justice doctrine or mapping of classical jurisprudence in Justice Krishna Iyer's work is not something which cannot be done otherwise. But if you are in a position to demonstrate a clear-cut tool which you are using to do this, that gives a lot of credence to your work. So simultaneously an iterative data collection and interpretation. So data collection, data interpretation and report writing is happening together. That is the main difference between empirical, quantitative and qualitative doctrine. In empirical research, your data collection is one phase, your data analysis is second phase, and report writing is a third phase. But in doctrinal qualitative research, all these things are merging together because you are correcting, you are interpreting, you are creating a new proposition. Now, I use this word, third thing, you are creating a new proposition, which is the net outcome of your doctrinal research. Are you getting my point? Now, next time when you engage with any such work, you please make yourself little aware whether are these things happening or not. So, and it is based on the data reduction and interpretation, decontextualization and recontextualization. Now, decontextualization means, suppose somebody is using in privacy judgment you would find, or in LGBT judgment you would find, Johar judgment. Lot of things have been said with a context. Now you remove sometimes that context and look how they look like. So mostly the issue is the rights of the people, special class people. Now if you remove the concept, right of people are otherwise, those rights are otherwise very precious. Now what is the recontextualization? Recontextualization is exactly what the Johar did. So they have provided the right, means the new recontextualization is that these persons deserve certain rights. So now a recontextualization, new terminology has come. They don't write Ms. or Ms. They write MX or something. Paper, column has been created. I was in, where is our friends from TIS? So they have already, So they have created a gender neutral hostel. It is fun to go there. I saw the other day I was in TIS last time, so I was taken in front of. So now this recontextualization is happening. A gender neutral hostel. I was very worried क्योंकि मुझे भी यहाँ करना पड़ेगा कुछ। ये बहुत जल्दी ये वाक्यार्थ जो है बड़ी जल्दी फैलते हैं। Already I have decided कि फॉर्म में ठीक करो जहाँ कुछ और भी जोड़ दो आप उसमें और आप कुछ कॉलम खाली छोड़ दो मैंने भविष्य के लिए। बहुत से काम करना पड़ेंगे ज्योग्राफिकली, स्ट्रक्चरली, सभी पूरी दुनिया प्रभावित हो गई। So this represents the information in matrix, displays of information, and coding, and all these things you have already done. Let us see what is this. Sorry. Now, coding of data you have already done to understand the underlying meaning. But what I'll also like to tell you here, a very interesting technique which these I can sort of share these things. Because what we need to do is when you deal with the data, you also need to apply certain techniques which are peculiar to the qualitative analysis. I'll share these 15 techniques. The point is because I have searched all these things when I realized, so suppose I am meeting a research scholar who is there to defend his or her PhD, or he or she is appearing in an interview for selection into the PhD. So suppose he or she comes and say that I will do a qualitative research or doctoral. I say qualitative and doctrinal is a method. What are the techniques? What is the difference between methods and techniques? देखो कितना क्राइसिस है। ये जो ड्रेडी साइलेंस आप देख रहे हैं ना, it conveys a lot. कि हम लोग बहुत पता नहीं रहता है चीज़, हम लोग उनको interchangeably use करते हैं. And we need to really understand. And this document I've studied. So the first technique is to identify the typology. So like a text is being read, how many typologies you can create? Types. So suppose I am looking at gender insensitive remarks. What are the types of remarks? isn't it? So typology of remark could be one typology. Second is taxonomy. Taxonomy means the domain analysis, which is used together for developing a taxonomy or a kind of a sophisticated typology. So if there is a further classification, have you heard of mind mapping kind of? So mind mapping, it brought management has become a very powerful tool. So this taxonomy has become a sort of a word to classify the things in a very kind of diagrammatic manner, to plot your things. So generally, when textual things are brought at a level of diagrams, classifications, you are using, exploring the text in a variety of ways. Now, third method is, which is also coming up here, constant comparison or grounded theory. Now, constant comparison, please remember, this is a method which law researcher employs very often without being aware. Constant comparison means within the text, you are comparing two positions or multiple positions of the holder. So like author is holding 2-3 positions, we are comparing how these positions are comparable. Or if there are 3 judges, like for instance in judges, we can compare, constant comparison. So we are looking at the evolution of text in that particular article. Constant comparison means in doctrinal research the text continues to be compared with the former parts to give a new idea. This is very important. And they say that we have to find out we can compare, so consistency, contradictions. Generally these are now, this is a very subtle kind of remark I am making. If you read and reread and read and read again, you will find certain consistencies and certain contradictions in the text itself, any type of it. Now, whether that consistency and that contradiction is by design or by chance, it is conceptual or it is accidental. You need to understand. So, and what does it mean? So sometimes, like tension between orthodox and progressive. The privacy judgment is basically conveys the tension between orthodoxy and progressive. 377 judgment also connotes the same thing, because these values are constantly in tension. So suppose Justice Adarsh Goel judgment after Nas foundation. Nas foundation was as good as Johar judgment. By all means, I always put Nas at a higher pedestal for various reasons. But if you read Adarsh Goel judgment, so it looks little orthodox. Why this tension? So if you compare, you will not simply compare, you will compare the reasoning and rationale. So a study of reasoning and rationale to qualify the expression of consistency and to qualify the expression of contradiction. Because contradiction is also a very important finding. It's not that, because sometimes I have seen the judges who in the beginning of their career were following a particular line, but later they have started contradicting the same line because of, like if you see, especially in labor rights movement. Now, labor jurisprudence is a very illuminating one now. It was never like that, because we were kind of a very, I would not say capitalist society, but capitalist values were very dominating. And after little liberalization, probably the rights of labor are environmental law. Environmental law was not at all there as a subject. It evolved through the activism of many people, that it came into being. So you read the consistency and contradictions in legal material very clearly. It is called a study of constant comparison. Now, constant comparison is not a casual expression I am making. It is a very, very settled expression, and this is one of the techniques of doctoral and qualitative research. Nobody will provide you the techniques detail about the doctrinal and qualitative, because you can only qualify, you can only justify a doctrinal or qualitative research unless you specify those techniques which are very, very specific. Now you can do, I am not going into the computer aspects which you have already done, because your computer does this thing very well, memoing it and all that. And sometimes you can, as a researcher yourself, support or contradict the thesis which is there. So suppose you are collecting the data about the dispute resolutions in a tribal society, and you come out with certain findings, and you can contradict the formal procedures that they are not, why they are not effective, why these informal procedures are becoming effective and kind of thing, why restorative justice is more effective than the conventional model of justice. So kind of thing. So when you use the information to corroborate or to contradict, it becomes then very, very important. Next is analytical induction. Analytical induction is a method used by a very renowned sociologist, Nenke and Howard Becker. They said that a hypothetical statement you have to draw, and you can choose your hypothesis, like I have told you that in this judgment Aadhaar. So you always begin with a hypothesis. So if I begin with the hypothesis that if the case involves a person of very high socioeconomic and professional strata, his chances are more and more of acquittal in bribery case or corruption case. So if this is my hypothesis, and now I am reading my literature to understand. So analytical induction means I'll induct from the writings and analyze those expressions to prove my hypothesis, to examine my hypothesis. So when you examine your hypothesis based on inductive logic, inductive and deductive logic I'm sure you know. So the technique is called the next is logical or matrix analysis. So logical reasoning, I think this doesn't require much. There are various ways to do this. Then event analysis, domain analysis. Domain analysis is very important, especially it relates to the analysis of language of people in a cultural context. I have seen a very interesting study from Mumbai Tata Institute in Criminology and Justice Department. You know what they have done? They analyzed the Domestic Violence Prevention Act. So on the one hand, they are putting the provisions of the law on the one side, and on the other side, they are asking the people, the complainant, that what kind of meanings do you derive from the provisions of the law? Do you understand what does it mean? Because we think that everybody tends to derive the meaning from the legal provisions the way they are. We think they are supposed to. But people are not supposed to derive the meaning that the law wants them to do. People have their own way of deriving the meaning, especially the people who are the stakeholder. So people who are into the problems of domestic violence as complainant, they think that your law says that there is a Domestic Violence Prevention Act, it gives justice, it gives support. They said, I mean to say when I come to register my FIR, this should happen. Oh, well, law says. So domain analysis is basically the language that the people tend to use or tend to derive from the meanings of that domain. Now this is very important because law is for the people are not for the law. So normally that is the one reason of the failure of social legislation in this country, because the laws are distancing from the people. So So it is not people's law, these are the state's law. There is a difference. So, because if you ask the people's expectations from the law and the way they decode the law or the provisions of the law, it makes a head of difference. So, some very nice study is possible. I have seen this study and it will be published soon in the journal which we are publishing here. So, people in cultural context. People in cultural context have different expectations, different perceptions. Like institution of justice. So domestic crime, domestic violence prevention act also provides certain institutions, like they provide desk officers to be appointed in the police station to facilitate the access to justice. We are not concerned whether it is happening or not. We are happy. अच्छा हम लोग अपने आप में खुश होते हैं ये बहुत बढ़िया नाम है. We don't even bother to ask how the people are decoding those things. And a study recently, a researcher who did PhD underneath from Orissa only, so she has done a wonderful work, and she has brought a lot of ideas where the research is showing, though the institutions are available, but somehow they have been created in a manner so that instead of allowing the access, they are in fact inhibiting the access. No, this is so unless somebody brings these things through the research, in fact, nothing happens. फिर तो सब लिखा ही है. पहले चिट्ठियाँ आती थी ना, कि लाख हादसे हो शहर में, खैरियत है तमाम दिखते हैं. तो लाख कितनी दुनिया में प्रॉब्लम हुए, लिख देना सब ठीक है. हम लोग वही है कि सब ठीक चल रहा है, लिख देते. ठीक कुछ नहीं है. आप किसी पूछो कैसा, सब ठीक है. ठीक कुछ नहीं होता. कोई आदत हो गई है ठीक बताने की. तो ये लॉ में तो सब ठीक है. लॉ तो लिखा ऐसा जाता है कि उसमें सब ठीक नजर आ रहा है. मैं ये कह रहा हूँ, डोमेन एनालिसिस is a contextual analysis of the law from the viewpoint of the people. Now it is a technique. It is a recognized technique. And then hermeneutical analysis means making sense of written hermeneutics. Hermeneutics is people of linguistic use. So making sense of written text, which we have done. Yeah. How the text, your text is written. A lot of meaning can be derived. I don't know how many of you are aware of content analysis. Content analysis is also a very powerful technique. A lot of work actually Western researchers have done about the content analysis of judicial opinions on so many things. There are very good papers on this subject. So, discourse analysis. Now, discourse analysis is the linguistic analysis of ongoing flow of communication. So, a lot of crisscross communications in the legal field are happening where viewpoints and counter viewpoints are being done. And if somebody takes, like already interpret talaq and LGBT right, there is so much of crisscross. A good research on discourse analysis is possible. Discourse analysis is an established method which is possible by bringing all these things into context. Again, pointing out the and now the semiotics. Semiotics is the science of sign, symbol, body language. Science, body language, judges की body language, lawyers की body language. It's very interesting to study. Semiotics is a technique of qualitative research. Semiotics is a qualitative method. Content analysis I have already taught. Now, ethnomethodology and phenomenology. Ethnomethodology and phenomenology, those who are bit of engaged in postmodern theories in jurisprudence, they will understand what do I mean. So basically here how the individual experience the world. So we are generally given the meanings by others that this is like this and you should think like this. Even our thinking is regulated. We are talking about privacy and liberty. I am saying our thinking is regulated because we are not allowed to conceptualize our own meanings of the way we perceive the world. And this is a very, very powerful narrative analysis where you are looking, so like if you talk to the victims of extreme sexual violence, and if you do the phenomenological studies which have been done elsewhere, they bring shocking details about the way they perceive the institutions of justice and law and the world and the society. Tremendous. So I think these are, but point is, these methodologies become important if you have that kind of subject for discussion. Narrative analysis I have already told you about. So around 15 techniques I have mentioned. Now this is a very precise elaboration of those techniques which can simply be used when you are engaged with, but you have to be a little creative with these things. And as I said, these things we generally tend to do, but sometimes we tend to forget. The last part I would just come to show you how we have done this gender notion work. It is since under publication, so I will not go much detail. Let us go to the main part. I'll take you to the table directly. So basically the work that was done, it includes the study of the mapping of the gender insensitive evaluations in around 50 selected cases, judgments of Supreme Court. So basically total 50 judgments were studied and 9 variables we looked at. I'll tell you about those variables. And these variables were coded and we tried to develop. Now remember, this is all textual data. Now we are trying to develop this textual data into frequency tables and even the cross tabulation using the software to depict the gender notions of judges as well as their impact on sentence. This is a Atlas TI based research. So basically we use this software. Let us see. So now this kind of tabulation is possible. So we are saying the 2-finger test, gender insensitive remarks. So negative, positive, not conducted. So we have collected, so these are the cases in which the occurrence is being shown. Cases with gender, so this is the cross tabulation where this test is being advocated and where the judges have made, the courts have made any gender sensitive. So if you see, in 39% cases it was not conducted and gender sensitive remarks were present only in 11 cases. So if you see in positive 71% cases, if this is the highest concentration where the 2 variables are coming together. You can analyze these variables in various ways. Now this is the outcome of the case. So 2 variables we are bringing together. What was the outcome of the case and the case where gender is, so the permanent, the fixed variable was the gender insensitive comments. So increased sentence happened in 2 cases, and I think overturned conviction is interesting because 80% is showing the conviction was overturned and gender insensitive remarks were made in 8 cases. What does it mean? So when more and more gender insensitive remarks are made, the cases are likely to be overturned for conviction. No? We are deriving it from judgment. No? I'm not saying that this is the end analysis, but it gives you certain idea because the things are interrelated. We are unable to see them sometimes in combination because manually you cannot see those things and because देखिए एक बड़ी साइकोलॉजी में केसेस है कि जो हमारा टेंशन होता है वो एक बार में एक ही जगह रह सकता है। आई डोंट नो कहाँ है आपका अभी, लेकिन एक बार में एक ही जगह। द मोमेंट यू शिफ्ट, so the same happens with information. That's why we have to plot the multi-dimensional information together so that at once we can see. Otherwise आप सिर्फ ये देखेंगे कि judge has made gender insensitive remark. But judge has made insensitive remarks. Does it have something to do with conviction? No, this is a demonstration. This is not a full scale. I am showing this kind of research is possible. So it is a great sight to see the judgment being projected in numbers. The data is being generated. So data being generated from judgment in itself is a kind of innovation. So age of the victim, marital status of the victim, sexual history of the victim, two-finger test outcome of the case, and these things we have made. So let us see a couple of things. Again, I think not all tables are here because we have probably reduced the table. So age of the, basically we are looking at, does it have something to do with age of the victim and gender insensitive comments? So let us see what is the distribution. So in 40% cases we are seeing the victim 18 to 25 years is experiencing the highest number of remarks made by the court when this age group was facing the trial. Marital status, again, so I am just, this is a demonstrator, you can choose more important variable. Sexual history, so it is shown, I think this is active history, 21 case and 11 cases experiencing the. Now what is inference? Inference we have to, now a thing that you need to know, lot of things can be given to you, like computer will provide you data, table, everything. Inference you have to do. No computer software is still ready, at the moment ready, which can provide you result also. Tabular results will not be provided by the software, because no software can be stronger than the human software. Reads emotion. You have to read. You have to draw the inference. And I always feel that that is the most significant skill. Same data I can give you, same data I can give you, everybody will draw a different type of inference. And that is the skill that you have to master. And that is where we are not very good at. So some exercise, you take table and analyze table from multiple viewpoints. And priority can you draw ideas? Any question up to this stage? बहुत सन्नाटा है, क्या हो गया? Tired? Shocked? Threatened? Distressed? Oppressed? क्या होगा? Happy? So, what is it? I just want to understand. What is the possibility? Suppose if you undertake a doctrinal or qualitative research, what is the challenge that you are likely to meet? or if you want to guide somebody, or if you want to do yourself. Do you think that visibly some techniques can be employed now and at least tried in this case? And you would be immensely satisfied. I am telling you, seeing these things doing, it is a great experience. I am telling you, because somebody has to change the trade. अभी तो मुझे बड़ा सरप्राइज हुआ, देखो मैं आपको बताऊं, कहने में कोई हर्ज नहीं है, वैसे तो मुझे जो कहना रहता मैं कहता, उसमें मेरा अपना तरीका है. So when I communicated this paper, which we have done, to चलो ILI को मैंने communicate किया जी, so they said a very interesting thing to me. They said we have never published any paper with tables. आप चलो इस बात को सुनना, this is not a small thing. The most reputed journal in the country, probably is one of the, I would say. So they said, कि सर इसमें figure, मेरे में figure भी थे, and he was worried कि उसमें I have put the figure of Atlas TI also, and somehow it was required. So they were quite interested in the paper. They said, I said, why have you not published any paper with data? They said, there was never any paper. So we have been publishing the large articles without tables for all these 100 years. What does it mean? It means we have been doing without data. There is no data, there is no primary research. There is no empirical research. It is, so I got a lot of insights that this is not a simple observation coming. This is a very terrible things coming before us, that this type of journal, most reputed journal, never had a publication consisting of tables and all. So because we never thought that there would be a paper sometime
With table.
with table. Because we have constructed and decided, so they were kind of in a lot of difficulty because of table हटाना पड़ेंगे हमें. चलो मैंने कहा वो तुम देखेंगे, but it's a great lesson for me. So I think if you start doing with some data-driven work, then you will change the narrative around. I'm telling you, and the subjects like environmental law, corporate law, even contract law, criminal law, IPR, a lot of data is possible. And this data can be utilized. Like published data can be used, like unpublished data can be collected. And the problem is we have a very unidimensional thinking. So if we have one thing, we think on it. But we are not bringing so many things which are available outside of the purview of the law, but that has tremendous impact on the application of laws and the functioning of the institution. So probably those things can be extremely relevant. So one more thing this has to. चलो रहने देते हैं, इससे ज़्यादा कुछ कहा नहीं, जो होना होगा आपका इतने में हो जाएगा. इसके बाद में कितने करूँ कुछ नहीं होगा. नहीं इसका फायदा नहीं, इससे देखिए कुछ चीज़ें रहती उसके बाद में कहीं नहीं, इसमें जो कुछ भी हो सकता था सब बोल दिया.
Maximum samples है यूज हो गया.
गीता में कृष्ण ने कहा कि भाई इसके बाद और बचा है, तो देखो तुम्हारा जो होना है उतने से हो जाए, इससे ज़्यादा ध्यान होगा नहीं जाता. उसके बाद फिर लिखा नहीं गया. 18 चैप्टर के बाद उनका खत्म है. उनका मैं कब तक बोलता रहूँ, युद्ध रुका पड़ा है. चला जा रहा है वहाँ क्लास में देखा इसको बंद करो, अब असली काम किया. कितने ज्ञान से अगर तुम्हें लड़ना होगा तो लड़ जाओगे और ठीक हो जाएगा. लॉजिक यही है मेरा. So I want some frank feedback. This is the closing. I just want a couple of feedbacks from your side. That I thought literally you should say that what you have done and it will be difficult. But what is your experience? Can I have one or two a person's, yeah. Just to have some idea, actually.
So may I? Can I
Please.
I have a question though.
Yeah, sure.
As you were doing this presentation and doing this presentation, you did refer to hermeneutics within qualitative research. But if you look at hermeneutic as an approach of doing research, it's an independent method where you sort of do textual interpretation. And most of qualitative analysis is also textual interpretation. So how do you see overlaps here? Because in certain disciplines, hermeneutic approach is considered as an approach, as a method of doing analysis. But then, if you were to include that as part of your qualitative research, then how do you sort of see overlaps? Because there are disciplines where phenomenology, for example, is a separate approach.
Yeah, it's a very good question. Basically, when I was talking about these things, I used the term techniques. What happens is when you have to collect the qualitative data, you have several options. Or I would say you can collect the data in a variety of ways. Now it depends on what is the nature of your research. So if your research involves, because these boundaries which we have divided between the subjects, these are the false boundaries. Knowledge is undivided. I say knowledge is undivided, what does it mean? There is a very typical thing which we experience, and I have also experienced, because I have studied in a university where I have seen all the departments separately structured and established. So psychology department, law department, sociology department. And seeing all these departments for all my times in the university, I had derived an understanding that these are the separate subjects. So they are separate buildings, basically. We have compartmentalized the physical structures also at the level of knowledge structures. So knowledge is indivisible. So psychology has a lot of psychology you cannot stop coming into law. Or economics you cannot. Rather I would say now law and economics is becoming very powerful. Law and psychology is becoming very. And rather I have seen in the US the most, Raghu was saying and other people, that a lot of courses are bringing a lot of interdisciplinarity. So what happens is the methods which were so popular in anthropology and sociology, long time we thought these methods are useless for law and legal research, which is not the case. Because law interacts with the people, law interacts with the society, and the moment you interact with society and the people, all the techniques which have grown in other subjects, they become automatically important. So what I feel is we can derive a lot from psychology. So suppose I want to understand the psyche of a terrorist, I can use the projective techniques or Rosha techniques developed in psychology. But if I want to understand the tribal civil dispute resolution system, I'll go for ethnography or hermeneutics or narrative analysis, which is too much successful with anthropologists. Or if I want to do another content analysis of legal material, content analysis, journalistic, the journalistic disciplines are doing very good with content analysis. So I borrow the techniques from so many disciplines, as long as your content is qualitative and you want to apply these things. So for me, this becomes important tools and techniques to collect the data for them. Because nobody will object you, why have you used a sociological technique for collecting the data in a legal research? So linguistic techniques, economics techniques, like economics was very strong in quantitative. So now legal informatics, geometrics, these are getting supported by a lot of us. So I think these boundaries are disappearing very fast. Though the core content of law will remain the same. But at the same time, the methodological developments happen in the field of ICT, economics. All these things become useful techniques. So as an approach also they become important, because as long as they are in a position to contribute to the research that you are doing, I think they are applicable and they are useful. Yes. Yes.
First of all, I would like to thank you for organizing this particular event. When I was applying for attending this particular program, my dean said that why you want to go, let junior people go.
Oh, professor doesn't want me.
Professor doesn't require this, so there is no need. I said, insisted that no, let me have a look, because this seems to be a new thing. I am immensely benefited by this from the beginning, starting from Dr. Srikula's session. I wish you could have spent some more time, because that is something which I personally felt that would have been better. As far as software is concerned, I believe if we would have brought our data along with us, or some work, that would have been more. That is the only aspect which I feel we did in abstract. Just to know the software, that something which would have been more useful to us.
With the
It was actually a mistake on our part that we did not bring it.
data.
But that data, I think a more emphasis on that has to be there. Then only you learn.
I fully agree with this.
So that is the only feedback with that. And congratulations for organization. Thank you.
Anybody else wish to say something? कुछ ख्यालात लेके मत जाओ अपने, जो मन में है आपको बोलो, ये मौके बार बार नहीं मिलते, इजहार ख्यालात होते रहते। Yes.
The way it was structured, it was really nice. The first day we really enjoyed it. But as sir has mentioned, when we started using Atlas TI, we slowed down a lot. One of the main reasons is that we were not prepared with our own data. We had to, read it. And I felt there was a little disconnect, if I can be honest, brutally honest. There was a little disconnect between us and the instructor, the resource person. I personally couldn't really connect with him because there were a lot of problems that we were facing using it. So the simple things, now the things that I understood by your presentation, they're very simple. I mean, we know how to use Atlas TI. Probably when I go home and maybe even do a case reading on Atlas TI and write my notes, it would be easier. But that couldn't have come. So at times, the quantity that you have to create 50 codes, or you have to put in 4 documents or 5 documents, the quantity outweighs the quality. We were at a beginner level. So if it could have been explained in an easier language, not necessarily slow, it was already very slow. So if it would have been more efficient, it would have been
A
more.
bit of a more structuring in terms of the problem. So जैसे आपने अगर कोई problem दिया, he dealt with a management problem, his own. If you would have taken a small maybe legal issue,
like some of the papers must have been sent to us in advance to read, which has been prepared on the basis of that class. So we should know that what is the methodology actually followed, what is the coding importance is. So I think we can be able to connect much better with the software.
I know.
So I would like.
Yes.
Sir,
Yes.
So even I also agree with sir because I had a computer application degree as well, so it was a bit easier for me. I have worked in C++, Oracle, Java, Core Java, so it was not that tough. But then because we have participants from different stages, so had it been the case, we would have like a uniform 5 cases that would have been shared with all the participants yesterday itself. And if we could have worked on those same cases and we would have learned from each other as well. So because I didn't face that big a problem, because I also had statistics in my college level, I'm an economics student, so it was much and a good thing for me. But then if it would have been much more uniform in the sense that it would, if all the 5 documents or the cases might be law or might be social sciences, and uniform 5 papers would have been sent to all the participants in the initial classes. So we could have done easily on that, from the beginner level as ma'am said. Otherwise, to be very honest, the most favorite of all the 3 days was Dr. Aparna Chandra's deliberation. I really felt that I needed that difference on case note and case committee, because I was also under a lot of, I did not have that much of knowledge about case note and comment. So it was very, very like enriching for me. And Amitabh Kunj ma'am's, I didn't ever think that jurisprudential aspect, and that was something very new for me, and I have really learned from the first day.
I'm very
Thank you, sir.
pleased to learn this. So I really got good feedback from you. Because see, this for us also, we were thinking how that can be done, because 3 days, the instructor wanted more time. Frankly speaking, I do some session in the beginning to create a kind of theoretical platform to understand and appreciate these things I do manually, which computer does through machine. So before doing with machine, I learned manually. So manually it is also possible, because we have been doing manually. So generally in the beginning, we provide some orientation, which I have done slightly because of my, I was busy. So I really regret I was not present on first day because I was away. But then he wanted a kind of day for familiarizing with the software and how it can. But I also realized that I never thought that this would be a complete training of using this software right here. It was only introducing a software to just trigger and give you a kick kind of thing, where you can go back and try to explore yourself. Generally, I tell you, when I was introduced long back with this, I was in the same situation, a lot of confusion. But this confusion is a very important stage of learning. If you are confused, then something continues. If you are satisfied, then nothing will happen.
So you're happy with
तो मैं confused बहुत, मैं चाहता हूँ कि कुछ आपकी जिंदगी में कुछ confusion बना रहे, क्योंकि that creates some thinking, churning some thinking in you. तो वो idea नहीं था. I wanted to just to sometimes surprise you, shock you, to see that so many things. So every time the knowledge is a progressive discovery of your ignorance. I don't know if it's a good. So it's a progressive discovery of your ignorance, in the sense when you are exposed to these new things. I never think that you should be a master in a workshop of 3 days, less than. But you are carrying something, a new idea with you. Because you are all kind of people with some maturity and some level. This whole course is not for fresher. You see, nobody is here who is too fresh. Everybody is some senior. We have kept this idea. Because I want a lot of self-doing in this process, which is possible only at your level. Now you will go back with certain queries, certain unfinished agenda with you, and these things will continue to haunt and bother. And let it be. And they will become a kind of strong motivation for you to explore. And I have seen a number of times I have seen these becoming very important pointers to start. And it has happened. Because this research methodology I am not teaching as a course. I am doing it as a movement. Everywhere I go, and that's why I really apologize. Sometimes I speak in a very typical way, which is sometimes too difficult and too embarrassing sometimes. But I mean to say that we have to come up to that level where we start taking research methodology seriously, which is not happening. I'm telling you, it is not happening. You look back to all kinds. But it is a very strong and powerful area where a lot of effort is needed. I cannot do anything alone. But over the years, I have seen a lot of people have joined hands with me in several other places. I said, on the workshop, I will not organize at any day. You go back and organize at your places. I can come sometime if everything goes well. I have been going to so many places across the country. And I really enjoy it. because इधर मेरे के लिए थोड़ा problem होता है, because I share a secret. I'm least effective in this institution because I have lots of other things to do. But when I'm away, I remember in UPS when I went for a workshop on SPSS. So I didn't realize, they said कि जरा आपको कम से कम 2.5 days को आना है. तो पूरा workshop SPSS, it was on SPSS. So I thought कि चलो कोई और भी होंगे मिलके करेंगे. उनका नहीं था, आप ही हैं अकेले. Will you believe? 2.5 days, morning to evening. But there were around 60 teachers and research scholars sitting. और मैं इतनी देर, morning 9:30 or 10 o'clock to 5 o'clock, daily, 2.5 days. I did. And several places I did in Orissa, I went there for 1 day, I did Goa, I went, and Hyderabad, lot of places. So I think more people have to come together to see that we do these things. So it becomes very, very important. And I think writings are very important. You promote the good reading. Reading is not happening, therefore writing is suffering. This is a very strange connection. We don't read much. We read only on cell phone or computer screen. We have almost relinquished the books, which is a serious development. I am telling you, these looks very mundane things, but I am telling you these things are very fundamental. I asked my students, I said, how many books you have read? Have you read the classics at least till now? Or any subject which you are interested in? And I think a lot of things will improve if you have more and more reading. Writing is impacted, and qualitative research is a lot is about good writing. Because you have to argue. So you have to argue all the time. So it is all about arguing well. So it is happening gradually, and I am happy that this group has come together, and I really thank you, each one of you, and I am really thankful that you made a very good group, and we will continue to stay in touch, and sometime again we will meet some of the other places. Because I keep meeting with a lot of people. I think more than 1,000 people have attended now across the country. So I don't know, I don't recall the exact number of workshops that we have organized, but all the time it is growing. So it's a great experience for me. I'm sure that it is a little different, because otherwise doing seminar and conferences keep happening. You are all expert, where you speak out and everybody is speaking. Here not much speaking is possible because we are into a very technical subject. So this is good, I guess. So NLU Delhi, as a matter of mandate, 2 workshops in a year we try to organize. You go back at your places, try to promote similar events, maybe for 3 days, 2 days, and make it thematic. Now I am going for thematic. This was a little thematic. So more thematic workshop on, like suppose sometime only on data collection, sometime only on data analysis, sometime on report writing, sometime on research proposal building, kind of thing. So you can do such things very easily. So it's good, it's wonderful to meet you here, and I'm sure you had a pleasant stay. And